Ghislaine Maxwell, once a British socialite and daughter of a media tycoon, became infamous for her partnership with Jeffrey Epstein. She was accused of recruiting and grooming underage girls for Epstein, making her a central figure in his sex trafficking ring. After Epstein's arrest and death in 2019, Maxwell became the focus of prosecutors seeking justice for his victims. Her 2020 arrest and subsequent conviction on sex trafficking charges marked a turning point, showing that even the powerful could be held accountable. Maxwell is now serving a 20-year federal sentence, but her legal fight continues. She claims a prior deal with federal prosecutors should have protected her from prosecution. The Supreme Court is now considering whether that old agreement shields her from her conviction. At the heart of her appeal is a controversial legal deal made in Florida over a decade ago. Ghislaine Maxwell's legal team is mounting a final, desperate effort. They are attempting to overturn her conviction by appealing to the highest court in the land, the Supreme Court of the United States. This represents a critical juncture in her legal battle. Their central argument in this appeal isn't focused on establishing her guilt or innocence directly. Instead, they are challenging whether the legal process of her prosecution was conducted fairly and legally. They are questioning the very foundation of the case against her. The core of their argument hinges on a 2007 non-prosecution agreement that Jeffrey Epstein entered into with federal prosecutors. They claim this agreement granted broad immunity not only to Epstein, but also to his alleged co-conspirators. A group they assert includes Ghislaine Maxwell. However, lower courts have previously considered and rejected this argument, finding it unpersuasive. These courts have ruled that the 2007 deal did not extend protection to Maxwell for her alleged crimes. Undeterred, Maxwell's legal team is now petitioning the Supreme Court, urging them to carefully review the case and determine whether the government potentially violated a legally binding promise made in the 2007 agreement. If the Supreme Court decides to hear the case and ultimately agrees with Maxwell's team, her conviction could potentially be overturned, even if only on a legal technicality related to the agreement. This appeal represents Maxwell's final opportunity to challenge her conviction through the legal system. The stakes are incredibly high, as a loss here would mean she will likely spend decades incarcerated in a federal prison. It's important to note that the Supreme Court agrees to hear only a small fraction of the cases presented to it each year. However, the court's decision in this case, should they take it, could establish a significant legal precedent with far-reaching implications. The fundamental question at the heart of this appeal is this: did the 2007 non-prosecution agreement in Florida effectively limit the ability of federal prosecutors in New York to pursue charges against Maxwell? The answer to that question will ultimately determine whether Ghislaine Maxwell remains behind bars, serving her sentence, or whether she is granted a stunning reversal and walks free from prison. The 2007 Non-Prosecution Agreement, or NPA, a legal document that has sparked intense debate and scrutiny for over a decade. This agreement, forged between federal prosecutors in Florida and the now-deceased Jeffrey Epstein, is now at the very center of Ghislaine Maxwell's appeal, a last-ditch effort to overturn her conviction. Back in 2007, Epstein managed to avoid facing federal charges by pleading guilty to what were considered lesser state crimes in Florida. As part of the agreement, he served a relatively short sentence, especially considering the gravity of the allegations against him. He was also required to register as a sex offender, a permanent mark on his record. But the most controversial aspect of the NPA was a specific clause it contained, one that appeared to offer protection to Epstein's potential co-conspirators, a phrase that has been interpreted in various ways ever since. This clause seemingly shielded them from any future federal prosecution related to Epstein's crimes. Now, Maxwell's lawyers are arguing that this very clause should extend to cover her, providing her with immunity from prosecution. This is despite the fact that she was never explicitly named or mentioned anywhere within the document itself. Her legal team claims that the agreement represented a binding promise, not just from the Florida prosecutors involved, but from the entire U.S. government. They argue that its reach extends far beyond the jurisdiction of those specific Florida prosecutors. However, critics have long condemned the deal as being secretive, deeply flawed, and fundamentally unfair. They point out that it effectively excluded Epstein's numerous victims from having any meaningful input or participation in the legal process. The architect of this controversial agreement was Alexander Acosta, who later ascended to the position of U.S. Secretary of Labor under the Trump administration. The perceived leniency of the deal and the circumstances surrounding it have continued to fuel controversy and public outrage. Now, the ambiguous and potentially far-reaching wording of this NPA has become the very linchpin upon which Ghislaine Maxwell's Supreme Court appeal hinges. If the Supreme Court justices ultimately agree with her legal team's interpretation of the agreement, it could potentially upend her conviction and throw the entire case into disarray. The government, however, is vehemently insisting that the original intent of the deal was never to provide blanket immunity to unnamed individuals on a nationwide scale. The NPA's inherent secrecy, coupled with its broad and somewhat vague language, has transformed it into a major flashpoint in the ongoing fight to secure justice and closure for Epstein's numerous victims. Now, Ghislaine Maxwell's fate, and potentially the future use of similar non-prosecution agreements, hangs precariously in the balance, awaiting a final decision. The Supreme Court is now tasked with the weighty responsibility to decide just how far the long arm of that old and highly controversial agreement truly extends. Maxwell's legal team is building their defense on a single crucial point, the non-prosecution agreement, or NPA. They frame this agreement as a binding contract, a solemn promise made between two parties. They argue that this NPA was a legally binding agreement between Jeffrey Epstein and the U.S. government, a deal struck to resolve past issues. The core of their argument rests on the assertion that the government, in this NPA, promised not to prosecute any co-conspirators who might have been involved with Epstein, and crucially they contend that this promise, once made, should be honored nationwide, across all jurisdictions within the United States. The defense argues that the specific location of her trial, whether it's held in New York or Florida, shouldn't have any bearing on the validity of this agreement. The promise, they say, is universal. Maxwell's lawyers go further, claiming that she is an intended third-party beneficiary of the NPA, someone who was meant to be protected by its terms. They argue that this protection applies even if she didn't personally sign the agreement or even know about its existence at the time it was made. The benefit, they say, was implicitly extended to her. They issue a stark warning. If the government is allowed to break such agreements with impunity, it fundamentally undermines trust in the justice system, eroding the public's faith in the integrity of legal proceedings. The Supreme Court is now being asked to weigh in on this complex legal question, specifically to decide if the NPA's language is sufficiently clear and unambiguous, and crucially whether that language is enforceable by someone in Maxwell's position, someone who claims to be a beneficiary of the agreement without being a direct party to it. Her team argues that fundamental fairness and due process demand that the government be held accountable to keep its word, to honor the commitments it makes in legal agreements. This obligation, they insist, exists regardless of public opinion or the intense scrutiny surrounding the case. While the lower courts have previously disagreed with this interpretation, Maxwell's lawyers remain steadfast, insisting that the NPA was explicitly meant to protect her from prosecution. If the court ultimately sides with Maxwell in this case, it could establish a significant new legal precedent, fundamentally altering how plea deals and immunity agreements are interpreted and applied in future cases. The implications of this case extend far beyond Maxwell herself. At its heart, it's a question of whether the government's promises once made hold any real meaning and can be relied upon. The outcome of this case has the potential to reshape the fundamental rules that govern federal plea bargains and immunity deals, impacting the way the justice system operates for years to come. The Department of Justice strongly opposes Maxwell's interpretation of the NPA. They argue the deal was only between Florida prosecutors and Epstein, not a blanket immunity for anyone else. The DOJ says the NPA can't bind prosecutors in other states or for crimes not covered by the original investigation. Maxwell, they argue, wasn't a party to the agreement and can't enforce it. The government insists the reference to co-conspirators was just to close the case against Epstein, not to grant amnesty to others. The DOJ urges the Supreme Court not to take the case, saying the lower courts got it right. They warn that siding with Maxwell would set a dangerous precedent, making it harder to prosecute complex conspiracies. For the DOJ, this is about upholding accountability and preventing loopholes for the powerful. Maxwell's immunity argument has already failed in 2 federal courts. The trial judge in New York ruled the NPA didn't protect her, finding it applied only to Florida's investigation and not to separate crimes in New York. The judge also said Maxwell, as a non-signatory, couldn't enforce the agreement. Maxwell appealed, but the Second Circuit Court of Appeals unanimously upheld the trial court's decision. The appellate judges found the NPA ambiguous and concluded it didn't shield Maxwell from prosecution in New York. They also agreed she had no legal right to enforce the deal. These consistent rejections left the Supreme Court as her last hope. The lower court's ruling set the stage for a final, high-stakes decision. If the Supreme Court declines to hear the case, Maxwell's conviction stands. If they take it, the outcome could change the rules for federal immunity agreements. The Supreme Court isn't deciding Maxwell's guilt or innocence. The justices are being asked if someone not named in a non-prosecution agreement, but intended as a beneficiary, can enforce it. Maxwell's lawyers want a clear rule. If the government promises immunity, it must keep that promise for all intended beneficiaries. The DOJ argues only signatories can enforce such deals, warning that broader enforcement would create chaos. The court must decide if third-party beneficiary principles apply to criminal immunity agreements. Their decision could set a national standard for how these deals are interpreted. The outcome will affect not just Maxwell, but future plea bargains and non-prosecution agreements. The stakes are high for the justice system as a whole. The Supreme Court has two options: deny or accept Maxwell's petition. If they deny it, Maxwell's conviction and sentence remain, and her legal avenues are exhausted. This would be a win for the DOJ and a signal that the NPA doesn't shield unnamed co-conspirators. If the court takes the case, it could lead to a dramatic reversal. Oral arguments would follow, and the justices could rule that Maxwell was protected by the NPA. If so, her conviction would be vacated, and she could be released from prison. Such a decision would set a powerful precedent for how federal immunity deals are interpreted. Most petitions are denied, but if the court rules for Maxwell, it would be a legal earthquake. The outcome will shape the future of high-profile prosecutions and plea agreements. Maxwell's fate, and the rules for government promises, hang in the balance. Maxwell's case is about more than one person. It's about the integrity of the justice system. It highlights the tension between holding the guilty accountable and ensuring the government keeps its promises. The secretive 2007 deal with Epstein allowed a predator to escape serious punishment, and now its wording could free his alleged accomplice. The case raises questions about transparency, fairness, and the power of prosecutors. If the Supreme Court denies Maxwell's appeal, it affirms justice for her victims. If they side with her, it sends a message that government promises, even flawed ones, are binding. Either way, the decision will echo through future cases, shaping how plea deals and immunity agreements are made. The justice system must balance punishment, rights, and integrity. Maxwell's Supreme Court fight forces us to confront what justice really means in America.